406. And both of these cases are Stout State of Texas versus William Atkins. The cause number that is F13-61406 is aggravated assault. Okay, sorry, y'all had to take that off. And now the other cause number, Mr. Atkins, is also F19-76362, and that is an aggravated assault family violence case. Are you one and the same person that's named in each of these cases, Mr. Atkins?
Yes, ma'am.
All right. And we're before the court today, Mr. Atkins, because it's my understanding that both of these cases have been pending. One is a case that you are currently on probation on, I believe, out of the F13 case. And the 19 case is actually a new offense. And we are here today before the court because we need to make some decisions on how we're going to handle your case. Does that make sense?
Yes, ma'am.
All right. And if the state, if you would please let the court know what your last offer was on each of these cases.
Yes, Your Honor. For both cases, state is offering 7 years in the Texas Department of Corrections.
All right. So as you heard, Mr. Atkins, the state of Texas is offering you 7 years in the Texas Department of Corrections. Have you and your lawyer had the opportunity to discuss that?
Yes, ma'am.
Okay. And counsel, is there anything that you need to put on the record, anything you want to discuss with the court today?
Not in particular, Your Honor, just the fact, just an admonishment. So Mr. Atkins can hear from the court what his options are to be able to fully understand. I think there may be an issue with something's needing some clarification from the court, and Mr. Atkins should be able to make a decision after.
Okay, all right. So with both of these cases, Mr. Atkins, let's start with the F13 case. That is the case that you're currently on probation for. On that case, you have an absolute right to a contested hearing. In other words, you can have a hearing before the court where you can bring in any witnesses that you want to prove to the court that you did not violate your probation, okay? Again, you have the absolute right to a hearing on that. The punishment range on that case is a second-degree felony. So therefore, you would, the court could sentence you anywhere from 2 years to 20 years in the Texas Department of Corrections, okay? And as I indicated with the probation case, you do not have a right to a jury trial, but you do have a right to a hearing, okay? And even though you can call any witness that you want to prove to the court that you did not violate your probation, you have to understand that the state of Texas can any witnesses that they want to prove that you did violate that, okay? And I also tell you that because you have two cases that are pending, which is the revocation case as well as a new offense, and the 203rd, Mr. Atkins, we will proceed on the revocation case first. So in other words, if you are currently on probation, we will handle that case first before we even proceed to the new felony case. Sometimes people feel as though, well, I want to handle the new case first. Well, you have to understand that we have to go in the order that things occurred, okay? So in regards to the F19 case, that is an aggravated assault deadly weapon, aggravated assault case family violence. That also is a second-degree felony. You have anywhere you can serve anywhere from 2 years to 20 years in the penitentiary for that case, as well as receive probation if you were probation eligible, okay? Now let me back up a little bit. On this new offense, you have an absolute right to a jury trial. We could bring 12 citizens in and they can determine your guilt, innocence, as well as your punishment. Also, you could have a trial before the court and the court could determine your guilt, innocence, as well as your punishment. We also have something in the law that's called an open plea. And what that would mean is that you would plead guilty to the offense. However, you would let the court or the judge decide what your punishment would be. So those are the options that you have on the new offense, the offense that is F19-76362. So the main thing that you need to understand, Mr. Atkins, is in regards to the probation violation case, you do not have a right to a jury trial. That is just the court deciding if you violated your probation and what your punishment will be. In regards to the new offense, the F-19 case, you do have an absolute right to a jury trial. However, you would not get to a jury trial until we first deal with the alleged probation violation. Does that make sense, Mr. Atkins?
Yes, ma'am.
Okay, and Ms. Hawkins?
Yes, ma'am. Your Honor, I apologize for the interruption. And I just want to make sure I understand my case. The new case is an assault, family violence, and I'm sorry, aggravated assault, deadly weapon, family violence, SBI case. And I think that's our first degree.
That is
5
a
to
first
99
degree.
range.
Okay, let me pull that one up. I had the old one pulled up.
Yes, ma'am.
Okay.
Thank you,
So,
lady.
thank you, Ms. Hawkins. So let me explain, Mr. Atkins, and now that I have the proper docket sheet pulled up, I had an old docket sheet. Because the new offense is alleged aggravated assault, family violence, serious bodily injury with a weapon, that is what we call a super ag. And what that means, it is now, it is a first degree felony. It is indicted as a first degree felony. So the minimum on a first degree felony in the state of Texas is 5 years in the Texas Department of Corrections. So on this case, your punishment range will be anywhere from 5 years in the penitentiary all the way up to 99 or life. Okay. And so, as I indicated before, on this case, on this first degree felony case, you have an absolute right to a jury trial. Bring those 12 citizens in to determine your guilt, innocence, as well as your punishment. And so, with both of those things being said and stated, Mr. Atkins, the ball's in your court in regards to how you want to handle and how you want to proceed on your cases. As I've indicated on the revocation case, we can have a hearing similar to what we're doing right now, and the court could determine if you violated your probation, and if the court does deem that you violated your probation, then you would be sentenced on that case. Technically, it would go down as a prior conviction because we'll be handling that case first. Once we handle the revocation case, we can then segue into the new offense, which is the first degree felony that's pending before the court right now. So as it stands right now, the state of Texas has offered you 7 years on both cases. If that is an offer that you would like to take, if that is an offer that you would entertain, those cases would run concurrently, meaning that they would go together. It would not, one would not be seen as a prior conviction. And those sentences would start at the same time. So do you have any questions for me, Mr. Atkins, that I can answer for you?
Yes, ma'am.
Yes.
Since they're both 7 years, does that mean it's 14 altogether?
No, sir. Since they're going to be not consecutive, since they're going to be running concurrently, what that means is they would start on the exact same day. Okay. So it would be 7 years total.
You asked a question about the open plea option.
I just
ask it because that's what we're here for. This is what the court is here for, to answer that question.
okay. Can I accept the 7 years?
You can actually have a conversation with your lawyer. So we will allow you to talk to your lawyer. And yes, if you want to take the 7 years, yes, we will allow you to go ahead and do that. As I indicated, Mr. Atkins, the cases will go together. So I don't want you to think that it's 7 years on one, you have to complete that 7 years and then 7 years on the other. They will run together, okay?
Yes, ma'am.
All right. So if that is something that you would like to do, we'll allow the state of Texas as well as your lawyer to get all the paperwork together, and we can handle it just like we're doing right now, okay? So I'll come back together in the courtroom just like we are. We could all be on the screen and we could take care of both of your cases at the same time. Is that something that you want to do, Mr. Atkins?
Yes, ma'am.
All right. Thank you so much for agreeing to talk to us today.
Judge.
Judge, excuse me for a moment. I'm sorry to interrupt. From prior conversations, and the question hasn't been asked, and I just want to get clarification from the court, from Mr. Atkins. Could the court admonish Mr. Atkins on the option of an open plea for both cases?
Okay. So as I indicated previously, you do have the option to have an open plea. Now, what that means is that with the revocation or with the new case, Mr. Atkins, you can bring down any witnesses that you would like to present to the court to either one, prove to the court that you do not violate your probation, or two, prove to the court that you did not commit the new offense. Now, what makes it an open plea is that you go in already saying that you're guilty. So you go in saying, yes, Your Honor, it is true that I violated my probation. And yes, Your Honor, I'm pleading guilty to the new offense. So once you plead true and you plead guilty, then you get to bring in any witnesses that you want to. However, the state of Texas can bring in any witness that they want to. And once all those witnesses are heard, then the only thing that will be decided is what the punishment will be, okay? Now, with that punishment, there is no deal in place. So this means that the court can look at the full range of punishment. That means on that revocation case, I could look at anywhere from 2 to 20 years in the penitentiary. And on the new offense, the first-degree felony, I could look at anywhere from 5 years to 99 or life. That 7 years would not be on the table anymore. Does that make sense?
Yes, yes.
Okay. And with an open plea, you could always go to the court for your punishment, or you could plead true and plead guilty in front of a jury. And a jury could give you that same, they can give you those same options. They could either find you, sentence you to anywhere from 2 to 20 years on the second degree, or they can sentence you 5 to 99 or life on the first degree. So the main difference with an open plea is either you can go open to the court or you can go open to a jury. But you just have to understand with either one of those, the only thing that you have absolute control of, Mr. Atkins, the only thing that you have absolute control of would be a plea bargain, because with a plea bargain, you know exactly what you're getting. You negotiate the terms, you and your lawyer can have control over that. If you go for an open plea to the court or an open plea to the jury, then that full range of punishment is there. And we have no idea what 12 citizens will do or what the court would do. Okay?
Judge, is it a possibility if the court heard testimony that it believes was sufficient, that probation was the best thing, that the court does have that option available?
Well, it would, I don't have the NCIC in front of me. If if the defendant were probation eligible, I would say I don't believe probation can be offered by the court.
The first degree.
Because of the nature of that case, only a jury would be able to give probation on that. Because in that first degree situation, that would have to be a deferred situation. Does that make sense what I'm saying?
Right, it would have to.
So with that one, it would it go down as conviction, basically. And once again, only a jury could offer probation on that. However, on the second degree felony, he's already on probation for that one. So it would just be a situation if the court deemed it necessary to continue that probation. And so right now, the offer that's before Mr. Atkins is that his probation would be deemed to be violated, and he would be offered 7 years on that one. And for the new offense, basically, Mr. Atkins would state that, yes, I committed this offense. In exchange for saying that he committed the offense, the state of Texas will offer 7 years on that case as well.
I said,
We can talk about it.
oh,
Okay. All right. And I'll let you and your lawyer talk about that. We just wanted to make sure, Mr. Atkins, that you had the opportunity to ask any questions that you wanted and that you can hear those answers directly from the court. Okay?
okay.
All right. You got any more questions for me?
No, ma'am.
All right. Counsel, do you have any more questions?
That would be it, Judge. Thank you.
All right. So, Ms. Hawkins, if y'all want to chat offline, you and Mr. Atkins' lawyer prepare paperwork that y'all need, and then we can reconvene with another hearing date.
Yes, ma'am. Thank you, Your Honor.
All right. If there's nothing further, we are off the record. Thank y'all.
Thank you, Judge.
So Judge, we're off the record. Can I just ask one thing?
Yes.
In the event that we have the paperwork completed, you have a timeline for us for our next hearing?
I will send out once y'all send the documents to me, I would then just send out a meeting invite.
Okay.
And, y'all want to do it, because I don't know what your schedules look like.
Yes, ma'am.
Whenever y'all get it done and say, hey, Judge, everything is signed on our part, because all I have to do is sign it and not just email it to my bailiffs. They print it out and Mr. Atkins can sign it. Or better,
Yes.
counsel is right there in the courthouse today. So if it's something y'all wanted to do today, we could do it today. It just depends on what your availability is. As soon as I get the paperwork, then I'll know that we're ready and I can set up a meeting anytime. I have a meeting at 1 o'clock, but other than that, I'm free. So
Okay, thank you.
y'all wanted to get it done right now. I just don't know the capabilities of scanning and email and all that between y'all two. But once I get the paperwork, I'm good to go.
Yes, ma'am. Thank you.
Okay.
Thank you, Judge.
All right. Thank y'all. Good luck to you, Mr. Atkins.
Thank you.
Okay. Thank you, Crystal.
It may have changed.